Welcome to Leveraging Inspiration, the Inspired Patent Podcast. There are 5 crucial strategy milestones for patents. In this episode, I cover the 5 essential milestones and what to look for at each milestone so you can ensure your patent has the best strategy for success. I'm Wayne Carroll, your host, here to share valuable insights, stories, and strategies for succeeding in intellectual property. Let's dive into the game of IP and learn how to win. This podcast is not legal advice, but is strictly educational and informational. Listening to, responding to me does not create or establish an attorney-client relationship. I'm happy to meet with you one-on-one, and then we can discuss having an attorney-client relationship, but at this point, this is informational only. The 5 essential strategy checkpoints for patents. The strategy for small and medium-sized businesses is different than for large businesses. A large business can recover or manage the loss if investing in a patent is ultimately not profitable. Small and medium-sized businesses, however, need to be more strategic with their resources. Obtaining a patent is not just one event, but it is a process. For small and medium-sized businesses, there are 5 essential strategy milestones, or for all businesses. In the process of obtaining a patent, for each essential strategy milestone, I will also discuss quality checks at each point, because if the strategy is based on bad information or the patent has bad quality, then strategy isn't going to be able to make up for that. The way to get good information, of course, is to check the quality of the process that obtained the information. The first of those processes and the milestone is patent research. Before preparing a patent application, it is essential to perform research to determine how much of the invention is already published. The results of a patent search are not necessarily binary, as in yes or no, for filing a patent application. Rather, there is a binary strategy decision to be made based on the research results of a patent search, of whether or not to file a patent. Quality in a patent search comes from multiple elements, and the following are 3 quality process elements when performing a patent search. First, verify that the researcher understands the invention and has a background in the technology area of the invention. The second one is ensure the references related to the invention are relevant. The references that are found in the patent search are relevant to the invention. If the references do not appear very relevant to the specifics of the invention, then the search may have not been done properly, or there might have been a misunderstanding on the patent searcher's part. The third one is check that the search results indicate searching in specific classes and subclasses that relate to the invention. The patent search should list where they searched in classes and subclasses. You should look at the titles of those classes. Does it make sense? Should your patent be in that class or subclass? The strategic decision of whether to proceed with filing a patent application should be made in the context of what claims are expected to be patentable after reviewing the publications found in the patent search. Sometimes it's possible to obtain a patent that will be very narrow and will be easy for others to avoid infringing. If the only question you're asking your patent attorney is whether the invention is patentable, often the answer is yes. But if the question is, what would a patent claim cover and what wouldn't it cover? The answer will better inform your strategic decision of whether to proceed with a patent filing. So for a patent search, we've discussed the quality part, and the strategic decision at this first milestone is whether obtaining a patent with the expected scope will provide a significant competitive advantage. Number 2 is the patent claims. The second essential patent strategy checkpoint is reviewing the patent claims. Patent claims are the legal rights of the patent that are granted. When the patent is granted, if you do not understand what the patent claims say and what they cover, you can't make a good strategic decision about whether they cover the patent rights you want for your business. Unfortunately, many companies do not understand the critical importance of patent claims until they go through patent litigation, where they must prove that every element of their patent claim is being practiced by a competitor. A patent claim with fewer elements is broader and easier to enforce because there are fewer elements that you have to prove in court to find infringement. For example, if a patent claim has 5 elements, then a competitor is only infringing if they have all 5 of those elements in their product or their process. If they only have 4 of the elements, then they are not infringing. Every element added to a patent claim narrows the scope of the patent. Sometimes patent claims contain elements that the patent owner is not even practicing or aware of, making the patent essentially worthless in protecting the patent owner's business. The quality of the claims can be measured by a process of preparing the patent claims. We use an 18-point checklist that covers critical technical details as well as strategy details. The first of those is verify that there will be a single infringer of the claim. Ensure that your competitors will infringe if they practice your invention, and not just your potential customers. An example is a patent claim that requires a software process to be implemented on specific hardware. If one company that's a competitor sells the customer the software and another sells the company the hardware, then it's possible that the only one infringing is the potential customer. And suing your potential customers is not often feasible due to cost and can be bad for business. So a single infringement isn't going to add up nearly as much as a competitor who's selling hundreds or thousands or even millions of sales based on your invention. The second quality strategy is review the claims to determine if they describe the invention as a mechanical system and a process if possible. Many times an invention can be claimed as both a process and a system. If both can be claimed, then this provides broader coverage for your patent, because sometimes a process won't have the exact structure and so it will be broader. And sometimes the mechanical system might not do an exact step that's described in your process, so it might be infringed in that case. So that's the second one, is review the claims to determine if they describe mechanical system and a process. The third one is check if means plus function claims are used. These claims use a language of means for and then what the function is. For example, means for turning a screw is means for function. Turning a screw is the function. It might include a screwdriver, a penny, a knife, and many other devices. If this language is used, then the specification needs to discuss as many different options as possible, because on these type of claims, only the options discussed in the specification are covered by the patent claims. This claim may look very broad, but in court, it is interpreted based on the specification, and we're going to discuss the specification next. The information you need to make a good strategic decision on whether the claims give you the protection you are seeking requires you to understand what the patent claims cover. The claims need to match your business plan for the invention. Your attorney can help you understand the claims and make sure they focus on what is most important to your company. Large businesses often have the strategy of filing patents on multiple aspects of an invention and directing the patent attorneys to make more of the strategic decisions about each patent, rather than the executives making or the owners making that decision, because the patents will have overlapping coverage. They spend a lot more money getting lots of patents, which isn't always feasible for the smaller, medium-sized businesses. It's an expensive strategy. So the strategic decision at the second milestone is whether the scope of the claims matches the business plan for the invention. And if not, do they need to be redrafted? The third strategic milestone is reviewing the written description. It's called the specification and the drawings that go together. In a patent application, the specification and drawings are technical documents that must disclose how the inventive concept is made and used. The strategy involved with the specification and drawings includes how much to disclose. Anything that you include in the specification and drawings that is not covered by your claims is donated to the public to use without your permission. You can, however, plan a patent strategy that includes filing multiple patents based on one patent application. Even if you do not plan to file multiple patents based on the specification and drawings of one patent application, it's important to discuss multiple ways that the inventive concept can be practiced within the scope of the patent claims. So for each element of the claim, that needs to be discussed and have a good discussion around different ways that it can be done within that claim. The specification and drawings can help broaden or narrow the scope of the patent claims depending on how it is written. As mentioned before, when you have means plus function claims, it is critical to discuss multiple options for the means to accomplish the function in the claims. We have a separate 12-point checklist for the specification and another 7-point checklist for the drawings to ensure the quality. Here are some strategy points that are also to be checked. We want to verify that there are descriptions of elements in the patent specification and drawings for every element of the claims. We ensure the specification and drawings discuss multiple options and ways to accomplish what is covered in the claims. It's always recommended to prevent the specification from limiting the application to a single described version or embodiment of the invention. So that's the first one, is multiple descriptions of each element. The second one is check if there are inventive concepts in the specification that are not covered by the claims. If the answer is yes, consider removing the inventive concepts unless you intend to dedicate these inventive concepts to the public, or unless you're planning to file separate patent applications for these concepts. If you intend to file serial continuation patent applications, and we'll discuss that strategy later, you can keep the patent pending. You also, if you're going to do that, you want to verify the specification and drawings are broad enough to have applications of varying scope. To make a good strategic decision about whether the specification and drawings meet your business goals, you need to have a plan for the invention and understand the strategic long-term and short-term strategies for a patent. Your patent attorney can guide you through the strategic options for your patent and discuss whether the specification as written meets your goals. So the strategic decision at the third milestone is whether the specification and drawings provide sufficient support for your long-term and short-term goals. If not, then they need to be redrafted. The fourth milestone, that's a strategy milestone in a patent application, is responding to patent office rejections. About 90% of all patent applications receive at least one rejection. Most receive more than one rejection. The patent office rejects patents in an office action that explains the reason why the patent is rejected. Sometimes the patent office only rejects some of the claims and states that some claims are allowable. In each case, a strategic decision is made whether to refute the reasoning of the patent office, accept their reasoning, and possibly amend the patent claims, or whether to cancel rejected claims so that only allowable claims are left in the patent application, which would then lead to a patent grant. So regarding quality and responding to a patent application, everything we write can be used later in court to narrow the scope of the patent claims, depending on what was argued or admitted in the response, the written response. To address this risk, we perform the following to ensure quality. Number one, we review the office action and the cited references, which usually those references are prior patents or published patent applications. We make sure we have a good understanding of the cited references. That will help us overcome the rejection. The second step we take is we conduct an examiner interview. In responding to a patent application, you're required to submit a written response, but we can interview an examiner and discuss legal arguments and amendments with an examiner without committing every word of the interview to the official record. And every word of the official record is what can be used against the patent in litigation. Now, a summary of the interview is entered into the file, but specific arguments made are usually not part of that summary. The interview also guides our response strategy and often reduces the number of rejections received. When claims are amended, first one was review the prior references. The second one is conduct an interview. The third one is when we amend claims, we check them for errors before submitting the response. We want to make sure that we don't get rejections at this stage based on technical errors, and which would prolong the process and delay getting the patent. The fourth one is responding on time. The patent office usually has a deadline of 3 months to respond to office actions, but an additional 3 months are available for a fee. Responding within the first 3 months gets the patent to move through the patent office faster, and there's less time for a patent examiner and the patent attorney to forget their work that they've been doing on the patent. Therefore, they can work together faster and get it through with less work. The average time between the filing of the application and a first office action is 16.2 months as of April 2023. During the time between filing the first office action, there may have been shifts in technology, shifts in your business goals, and the market condition. To make a good strategic decision about the patent, it is important to consider if any of the goals for the business relating to the patent or the invention have changed. A high-level review with the assistance of an experienced patent attorney can often provide important information about the decision to continue to fight for patent rights. So the strategic decision at the fourth milestone is whether there is a feasible and realistic opportunity to obtain a patent that meets your business needs. As I said, with filing a patent, there's often opportunities to obtain a patent that is too narrow for your business needs, and it might make sense not to go forward. The same can be true after an office action. We hope not, but it does happen that the available and possible and realistic opportunity to obtain a patent will either be too costly or will not have a broad enough scope. So the fifth strategic milestone is after the approval of the patent, called a notice of allowance. Some might think that the work is done once the patent office has given the green light and said that the application is ready to be granted as a patent. But this is one of the most important times to consider strategy and quality. For quality, sometimes when an amendment is entered by the patent office, they make errors. A comma or a period out of place can be costly to correct later, and if not corrected, may be the difference between winning or losing a patent lawsuit. To obtain a quality patent and avoid costly errors, we go through the first 4 steps again with the following additions. First, we verify that the references from the patent search and any additional relevant references were entered into the file in the patent office. The inventor or the applicant of the patent application has a continuing duty to disclose references that are relevant until the patent issues. If you learn about a reference, for example, from another patent filing, like if you filed a foreign filing on this same patent and that foreign patent office sends you back a reference that you hadn't seen before, it needs to be cited in the patent. And it's critical that we do this quality step to check if there are any new disclosures that we need to give to the U.S. Patent Office. If you don't, the patent could later be invalidated. So the first one is ensuring references are disclosed. The second, verify patent claim amendments were entered correctly. An amendment can be filed at this point before the patent issues, and you can correct errors. And oftentimes, the examiner does need to look at it, but oftentimes it's very clear these are minor technical issues, and therefore we can just go forward. If there are errors and the patent office needs to do some more reconsideration, you want them to do that reconsideration to make sure it's done right. So the second one was verify there aren't errors in the claims or amendments. The third one is review inventorship of the final claims. The inventors who are listed on the patent are only those inventors who contributed to conceiving what the invention is in the claims. An inventor may need to be removed from the patent if all the claims related to that inventor's contribution have been canceled. If they were responsible for a certain embodiment or a certain feature, and you decide through the patent process that you're not going to pursue those claims, then that person actually needs to be removed. That can be fixed later, but it's easier at this point, and it's much less expensive. So the third one was review inventorship. The fourth one is check that the proper fees have been paid. The fees paid to the patent office depend on which discounts you qualify for. If you paid fees in the past under a discount that you did not qualify for, this is the point before you finalize the patent to correct the problem. Oftentimes, companies will grow or they'll be acquired by another company while the patent is pending, and therefore their discount status will change. This needs to be corrected as well. The fifth one is verify that priority claims are properly made. A patent application can claim priority to or claim the filing date of another earlier patent application. If it's not done correctly, then the references, publications, other patents that are after that priority date can be used to invalidate the patent. That can include the company's own website and marketing materials. So it's critical we make sure we have the priority correct in the patent application. So those were the 5 quality checks. Patent litigation is very high stakes litigation, with judgments in the highest cases reaching over $2 billion. In 2020, The total combined damage awards for all patent lawsuits in the United States was just under $5 billion. And that was between 51 lawsuits. These are the 51 lawsuits that did not settle and where the plaintiff, the patent holder, won. So that's not all the patent lawsuits that were filed. This is the patent lawsuits where there was no settlement and we went all the way to a judgment and the plaintiffs won. For these lawsuits, the average damage award between the 51, so you take about $5 billion, divide it by 51, it's just under $100 million. So the potential for damages can be near $100 million as an average. A patent, when you're litigating something for $100 million, that's the risk you have at stake. Then the patent will undergo very close scrutiny. Every lapse in quality can be used to limit or invalidate the patent. Every word of the patent file, not just the patent that's issued, but everything we file from the beginning, every argument we make, every word in that file will be scrutinized to see if there's some way that the defendant, the accused infringer, can get out of being held accountable for stealing that invention. So if you want your patent to be worth $100 million, then it needs to have quality built into withstand the attacks. There is also a strategic opportunity when you receive the notice of allowance. The opportunity is to keep your patent pending. You can complete the current patent and allow it to grant, and at the same time file a continuation patent that allows the patent to stay pending. The continuation patent application, however, must be filed before your patent is granted. In patent litigation, some of the ways that your competitors may avoid the patent will be things that you can change in the pending patent. As I mentioned before, if there are 5 elements and they only do 4, then you can use the pending patent application and attempt to get a patent that just has those 4. Or if they have 4 plus an element you didn't claim but is disclosed in your application, then you might get a patent with those 5 elements, and therefore they're infringing. By having that pending application, it makes it much harder for your opponent to avoid your patent because now they have an ongoing changing patent that they have to avoid. So the strategic decision when you receive a notice of allowance at this 5th strategic milestone is whether to file a continuation application to keep the patent pending while also having the patent granted. I'm Wayne Carroll, founder of Inspired Idea Solutions Law Firm. I offer a free strategy session at any of the 5 strategy milestones. Thank you for listening to Leveraging Inspiration, the Inspired Patent Podcast.